What's up? Your assignment from Tuesday?
Was the freedom of religion, was that due Tuesday as well?
No, that's due today. It didn't get published. So apparently none of y'all asked no questions. There was no assignment yesterday. I wasn't here. Y'all apparently just thought like y'all got a day off. I don't know why.
Thank you.
What up?
How are you doing?
Wonderful.
I was here yesterday. We had this weird like did not like it.
Well, I apologize. My daughter had pink eye, so.
Oh really?
Yeah. So my wife was out with her on Wednesday. I stayed home yesterday, and then my daughter is good enough to go back to school now. What's up? Who does? Brucey? What, Brucey? Like now, it's already open, brother. Can I help you?
Where's the camera?
Right there.
Oh.
Yeah, nobody needs to see you. No, seriously,
Hey
nobody
guys.
needs to see you. Go sit down. All right, hey, listen up. Hey, listen. That's my polite way of saying stop talking. I can be far less polite if that's what the situation dictates. Yeah, here's the deal. Yesterday, I mentioned a minute ago, there was supposed to be an assignment. I put it in Canvas and never published it like an idiot until finally somebody in 5th period was like, hey, is there no work today? Apparently y'all thought you were just gonna get a free day off. Okay, no such thing as days off, all right? So your freedom of religion assignment is due now tonight. Instead of making it due last night, since it wasn't actually published until like 1:30 in the afternoon, it's due tonight. You have a quiz tonight as well. I recorded this last night, and I recorded it actually in Canvas, and I will never do that again because Canvas sucks. I don't know what happened, but for whatever reason, like I did everything correctly, and I uploaded it, and then Canvas gave me a little error message. It was like, oh, we did something wrong. So now, instead of actually talking about freedom of speech and freedom of religion, which is what I wanted to do for like 20 minutes today, we have to do this instead. Oh, why are you? Start the video. Hey, can y'all hear me? If you're on Zoom, Bruce, unmute yourself for a minute and tell me whether or not you can hear me. Can you hear me? Bruce, can you hear me? He said yes? Okay, wonderful. All right. Hey, this is going to take the whole period, so we're going to get going right now because this is going to take a while. So this is civil rights. We've already done civil liberties. You need to understand, and I know I mentioned this before, civil rights and civil liberties are not synonymous with one another. Okay? They are not the same thing. Civil liberties are protections against governmental action that apply to you, the individual. Civil liberties are protections against, civil rights are protections against government discrimination that apply to groups. Okay. If you sue for your individual civil liberties, right, that Supreme Court ruling applies to you and you alone in your individual given situation. If you sue for a civil rights violation and it goes to the Supreme Court, that civil rights issue applies to everybody in the same subset of the population as you are that was being discriminated against. We'll talk about that more as we move forward. I'm going to kind of gloss over the struggle for equality here just because we already talked about equality, right? Y'all remember that? Yes, maybe, right? We talked about equality in terms of our beliefs and our sort of foundational ideals because we don't actually believe in equality, right? The reality is the only way to obtain true equality is basically to put everybody at the lowest common denominator, right? Meaning that if we really wanted to obtain equality in the United States, ultimately we would have to make like everybody poor and everybody stupid and everybody like miserable, right? Because you can't make everybody rich. In fact, if everybody's rich, then ultimately like pretty much everybody's poor, okay? Because then wealth becomes, it doesn't matter. Anyway, so we don't believe it, right? I need you to understand that. We do, however, believe in this concept down here, inalienable rights, right? We did talk about that. That's really what we're going to be talking about today, right? So we talk about civil rights. We're sort of talking about inalienable rights. For the most part, constitutionally, you need to understand our Constitution was obviously flawed, right? So you should have learned in a U.S. history class, like Jefferson sort of had this idea that all men are created equal, except we were literally only talking about men. Sorry, ladies. This class is like all girls almost. Yeah, I never noticed that. Okay, so sorry, ladies, you're just kind of left out in the cold on that one. And then if you're not white, you're left out in the cold, obviously, as well. That's rectified, and it's predominantly rectified really with the 14th Amendment. So we do have sort of equal protection. In fact, there is a clause in the 14th Amendment called the Equal Protection Clause that provides equality under the law, right? So when we look at civil rights and we look at whether or not the United States government is going to discriminate, one, the United States absolutely discriminates, and you need to understand that. In fact, the United States discriminates against you because you are not afforded sort of some of the same privileges that I am, right? Like, how many of you in this room can legally drink? Just me? Oh, so that's age discrimination, right? And now Mixon's like, you don't want to challenge that. That is, I'm being discriminated against. I need to be able to have a beer. And what? Of course there is.
I thought like, no, because old people get like discounts at Denny's and stuff.
Well, that's a little bit different, and we'll actually get to that. We'll get to that sort of concept as it pertains to businesses and things of that nature. But a lot of those things are in reality like the Denny's like senior menu. That is a menu that is designed for older people who actually eat less, right? Like as you get older, you will eat like when you're actually like old, you don't eat very much at all. Like you start to eat like a baby again. Like in reality, life, just so you understand, life's kind of like a bell curve like that, right? Like you learn and you grow and you like experience new things and then you like start forgetting stuff. And in both instances, like you begin and end your life in diapers, right? And basically other people have to like bathe you. Right, so that's what you have to look forward to in old age. But yeah, and now what you need to understand is in the event that we're going to discriminate, and the government is allowed to discriminate, but in the event that the government is going to discriminate, the government has to meet some requirements, and the government actually is the burden of proof. Right, burden of proof is a concept you need to understand legally. Burden of proof falls upon the government, meaning the government has to prove that there's a compelling public interest in what they're doing. There's no other way to accomplish the law other than to discriminate. Okay. Now, with that, there are different classifications for discrimination. Age discrimination, not really a suspect class, right? The reality is like you can't vote, you can't drink, you can't drive a car until you're 16. Like you understand why my 5-year-old should not be allowed to drive a car, right? Yeah. Okay. So age discrimination has a very, very low threshold of scrutiny. The strict scrutiny goes to or is applied to what we call suspect classes, meaning classes of individuals that have been historically discriminated against, which are predominantly ethnicity and race related issues. Gender has intermediate scrutiny. So again, we do have some gender discrimination, but it's a little less, there's a lower threshold to discriminate on gender than there is to discriminate on the basis of race, right? And again, if you think about it in terms of like discrimination, you obviously understand that men and women use different restrooms, right? Different locker rooms. That's actually a form of discrimination, just so you understand, right? Yeah. Technically, legally, it's discrimination. Anybody have a problem with it? Yeah, exactly. Okay. Which is why there's less scrutiny to that. You can look through this on your own if you like, but this is basically what I was just talking about, right? The classification and then the standard of review, and then basically how the Supreme Court is supposed to apply this stuff. For the most part, when we talk about civil rights and civil liberties, and we'll jump around a little bit, we'll talk about some other aspects. But most of you know, because you learned in a U.S. history class about like the civil rights movement in American history that happens in the 1960s with African Americans, right? And this is Dr. Martin Luther King Jr. meeting with President Johnson. There were instances in which they worked together. And then there were some instances in which King basically was like, I'm tired of waiting on you, so I'm just going to do my own thing. These are just different things we'll talk about as it pertains to African American civil rights and throughout the course of history. So there's a fair amount of like historical discussion to this. Obviously, you can't talk about sort of the struggle for civil rights in America without talking about slavery, because obviously slavery existed in this country for roughly 250 years. And the Dred Scott case, as it pertains to slavery, Dred Scott sued for his freedom because he was taken to a free territory. And this is probably one of the worst or least humane decisions in the history of the Supreme Court. The Supreme Court essentially said Dred Scott had no more standing to sue for his freedom than what your like microwave has to sue for its freedom. Okay, black men or slaves specifically were basically equated to like property, an appliance, an animal. They had no legal standing to even seek any sort of justice in a court of law, which is obviously pretty catastrophic. One of the things that it does, though, the 14th Amendment is going to overturn this case, right? So again, this is not a case you could write your dissenting opinion on that's due next Friday. Once we abolish slavery, we have probably a roughly a 10-year period. It's actually a little bit longer than 10 years. Reconstruction goes until 1877. But we have roughly a 10-year period in which blacks in the South are afforded, black men, again, just men, sorry, ladies, you don't have any rights yet, right? But black men are afforded sort of their rights, right? They're allowed to vote. They actually hold office. They do all sorts of things while the Republicans are controlling the South following the war, right? So Lincoln was a Republican. He abolished slavery. We call them now the radical Republicans in Congress. They oversee Reconstruction. They actually have federal troops stationed in southern states that prevent white Southerners that have been in power from ever from beginning to do things systematically to take away blacks' newly found federal rights. When Reconstruction ends, and it ends in sort of a pseudo shady backroom deal, obviously blacks are limited again in their sort of rights, right? The old school, the old predominant white ruling class that had ruled the South begins to take over again. They create segregation, legal segregation. They institute things like sharecropping, and they create black codes that require like black men to have a job. And if you don't have a job, you go to prison. And then when you're in prison, basically you get leased out by the prison to work on a farm, which sounds like slavery, right? Even sharecropping, if you understand anything about sharecropping, if you ever learned about it in a U.S. history class, it's basically tantamount to economic slavery, right? Yes, they have their freedom, but the economic system is rigged so heavily against them that there's ultimately nothing that they can do. This is I forget when this photo was taken. Obviously, this is during the segregated South. And what you notice is you have sort of separate water fountains. Now, water fountains are a really good example of this, because the reality is what comes out of this is the idea of Plessy versus Ferguson, which is a Supreme Court case that establishes the precedent of separate but equal. Right? So if we look, is this equal? They both getting water? Is it the same water? Right? Same pipes, right? So you got the same amount of calcium or chlorine or lead or whatever's in the water. It's the exact same water, right? It's just coming out of two different water fountains, right? Therefore, you've got some equality here, yes? That's what Plessy versus Ferguson decides. And it's separate but equal is okay so long as it's actually equal, right? So if you take like segregated buses in the South, everybody got on the same bus. The fact that the black people sat in the back and white people sat in the front, oh well, right? That segregation is deemed legal under Plessy versus Ferguson. And this begins to change actually in the 1950s first as a result of education and economic opportunities. Again, hopefully you had a U.S. history teacher that would have shown you the difference between a black schoolhouse in 1950 and a white schoolhouse in 1950. A black schoolhouse in 1950 in the South, obviously we're talking about the South here, but if I showed you a picture of a black schoolhouse in 1950 in Mississippi, you might mistakenly believe that that picture is from like 1850. It was generally like a one-room building, right? You had like a single bench, and that was pretty much it. Like no chalkboard, no books, nothing like that. 1950 schools in white neighborhoods are sort of indicative of what schools look like today. Like kids had desks and textbooks. Instead of a dry erase board, you had a chalkboard, but like, I mean, obviously no smart boards or computers or anything like that. But the difference in what those two groups had is sort of really significant. We have early on, even before we have Brown versus Board of Education, we have some issues with higher education, and Sweat versus Painter here is one of the good examples. It's actually a Texas case. It's about the University of Texas and whether or not UT could deny a black man acceptance to its law school in 1950. The Supreme Court says you can't base solely off of race. Basically, he had met all the other requirements, and there were no law schools at an HBC in Texas, right? So like Prairie View A&M, that's an HBC. Y'all know what HBC is when I say it? Historically Black College. Okay, so Prairie View A&M is an HBC. They didn't have a law school at the time. So if this man wanted a law degree, his only option, his only recourse was the University of Texas. And so ultimately the Supreme Court says well, you can't deny him acceptance or entry into the school solely because he's a black man. So ultimately what they do is they create a law school at Prairie View A&M in order to be like, nope, now you got to go over there because it's separate, but it's equal, right? The reality is we'll get to the point where even that really isn't equal. And part of the reason, well, we'll get to that in a minute. Brown versus Board of Education, that's primary and secondary education, right? So that's elementary school and then like junior high and high school. This is going to overturn Plessy versus Ferguson. This is the specific case that overturns Plessy versus Ferguson because it realizes that there is inherent inequality in separation, right? So if we were to go back to this photo, right, you should actually realize that even though I told you like, oh, it's all equal, right? It's the same water, it's the same like everything, it's the same temperature, same composition. The very fact that we identify a specific water fountain for this individual and tell him he can only drink from this one is telling him that he is less than. Everything else here is equal. But the very separation, and we realize this, or we codify it, we write it down in Brown versus Board of Education, the very fact that we separate shows that there is inherent difference, right? And that therefore separate is inherently unequal. And so we get rid of that, all right? Now, it is important to understand this concept down here at the bottom, de jure segregation versus de facto segregation. The jury segregation is segregation by law, right? That's what we had in the South all the way up until Brown versus Board of Education. De facto segregation, right, is segregation that we have sort of done to ourselves, right? It's sort of by our own choice. So when you look at the discrimination, right, if you have discrimination by law, that's the jury discrimination. If we talk about like the school that I used to teach at in North Carolina, okay, it was the historically black high school in Guilford County in North Carolina. And when I taught there in 2014, that school was 98% African American. Okay, 98%. In the years that I taught there, I had 2 white kids. That was it, and they were sisters, and they weren't even from the United States. They were from Albania. And I had like 2 or 3 Hispanic kids and like 2 or 3 Asian kids. I mean, the whole school was basically black. Okay, that is de facto segregation. And we move into neighborhoods with people that look like us. And if you don't believe that, go look at any major city in the United States today, right? Because in every single major city, you will find a neighborhood that is called like Little Italy, right? Or Chinatown, right? Or some other ethnic group. If you go to Michigan, there are neighborhoods in Michigan in which street signs, like public street signs, are in Arabic because of the massive Arabic population that lives up there, right? That is de facto segregation. We do it to ourselves. And this is going to become an issue or a question because what can the law do about that? And so if we look, right, like this is 1954 here at the very beginning of this graph, we see that schools were segregated. And this is specific to southern states, so understand that. And this graph is specific to like our 11 southern states. Okay, but even 10 years after Brown versus Board of Education, we still have not desegregated schools. Because again, when you have segregation within neighborhoods, within communities, within housing, and communities send kids to specific schools, you still have segregation with schools. We actually have a Supreme Court case, and I think it was Swan versus Mecklenburg County Schools in North Carolina that tests the validity of public busing. And if you don't know what that is, you clearly didn't listen to the primary debates when Kamala Harris and Joe Biden got into it over whether or not Kamala Harris should have been put on a public school bus, driven past 2 schools, and sent to a 3rd one in order to allow her to go to school with some white kids. And that's what the concept of busing is it creates diversity within the classroom. Okay. And I'm gonna be honest with you, that diversity is significant. And I forget where it is in here, but we will get to it, I promise. As far as public policy goes with the civil rights movement, this is pretty much history. I don't really care about this, but you need to know that obviously it was both blacks and whites that were fighting for it. And they're using civil disobedience. Okay? They were intentionally breaking the law. They're trying to get arrested. They're trying to challenge cases in courts. They're trying to end up on television in order to show people sort of the negative aspects to it. Okay? Voting is really significant in terms of anti-discrimination or civil rights history or civil rights law, because obviously we know with the 15th Amendment in 1865, black men get the right to vote. They get to vote for roughly 10 years, and then that vote is systematically taken away from them through all of these different things right here, right? So you have literacy tests. You know, literacy means the ability to read, yes? Good, then you're all literate, wonderful. You need to understand that's not really what a literacy test was. It's not like they gave you green eggs and ham and was like, hey, can you read this? No. Okay. Some literacy tests were things as ridiculous as reciting the Constitution from memory. Not the preamble of the Constitution, which like kids used to be required to memorize like in 8th grade, right? I'm not talking the preamble. I'm talking the entire Constitution. All of this. There you go. That's the extent of what you know. Yep. Correct. Okay. Some literacy tests were like 100-question tests that would ask you things like, who is the leader of the Senate? Anybody know the answer? No, like what position? Not the man, not the person. What's the position? Vice President, correct.
Oh,
I know. Like you was just pulling things out your butt. Like, hey, let's see if this sticks. Throw it up against the wall, see if it sticks. Right? Or what's the old expression? Run up the flagpole and see if anybody salutes it. Okay, those aren't jokes. Those are old expressions. Idioms. You know, an idiot. Never mind. Go ask your English teacher. Now, some literacy tests were even worse because theoretically, right? Like theoretically, you could memorize the Constitution, right? Or you could study enough to know like how many states were required to ratify the Constitution in 1789 for it to become the supreme law of the land, right? Like you could study that stuff and learn it. Some literacy tests were so ridiculous, they were like parlor tricks. Like there would be a massive jar of beans. Your literacy test was, how many beans are in a jar? Like, and it's not like you could open it up and start counting it. No, like how many? You're never going to get that right, ever. And white people that couldn't do these things, they have something called grandfather clauses. And I've seen this sometimes show up on lists of like racially charged terms. It's really not. Grandfather clause is simply a legal term. It's been applied to all sorts of things that have nothing to do with like discrimination or race relations. But basically, a grandfather clause says the law changed. You were doing it before, and you were not allowed to do it after because of the change in the law. However, since you had already started, we're going to let you continue. And just so you can understand, in like terms of racial issues, in the 1970s, they changed the drinking age from 18 to 21, right? And they basically did it overnight. They didn't, because what they did is they said on January 1st of 1978, okay, or let's say 1979, the drinking age is going to go up. And so if you're born in 1960, and you can drink at 18. On January 1st, 1978, you can drink at 18 because that's legal. And they pass a law that says you have to be 21 to drink. And basically what they do is they up it by a year every year, right? So if you were born on January 1st of 1961, can't drink. You were born December 31st of 1960, one day earlier, right? You can drink at 18 and you can continue to drink at 18 even as the law changes, right? One day later, you have to wait 3 extra years in order to get a drink. And so that's the concept of a grandfather clause, right? Because you're not going to take a 19-year-old or a 20-year-old who's been able to legally drink for a couple of years now and be like, oh, we changed the law, now you can no longer do this, okay? So grandfather clauses were things that were applied to the white people at the time, right? You were allowed to vote. You've been allowed to vote. Now we have a literacy test. You can't pass the literacy test because you're illiterate, but we're going to continue to let you vote anyways via a grandfather clause. Poll taxes were simply voting monetary requirements. I'm going to be honest with you. So this is fixed with the 24th Amendment, and it's becoming an issue again today, right? So I actually went and voted last night. You know what it takes to vote in the state of Texas? You need an ID. You know what type of ID? There's like 7 different IDs that work. Of the 7 different IDs that work, only one of them, a U.S. military ID, is given to you free of charge. All the rest, you have to pay to get, right? Like how many of you have a driver's license in here?
How many of you got your driver's license for free? None of you?
How did you get it for free?
What?
How did you get it for free?
You can't.
Exactly.
Okay, but here's the thing then. If you can't get a driver's license for free, if you can't get a Texas state identification card for free, and it's a requirement to vote, are you required to pay to vote? So do we have a free election?
No.
Possibly not. And this is something that is coming through sort of the court system and working its through now, because you have a number of states, a large number of states that have enacted voter ID laws that require people to have a specific type of ID in order to vote, and those IDs are not free. And in which case, the concept of free and fair elections, which is absolutely essential to a democracy, might be in violation because our elections are no longer free, right? Now, if you read enough QAnon stuff, you probably don't think they're fair either. Okay. White primaries, the last one up here, basically primaries were for whites only. So you weren't denying them their voting rights. But by having white only primaries, you basically put like candidates forward that promote only white issues, which eliminates that. The 24th Amendment is what gets rid of poll taxes. Ironically, this case right here, which is 2 years later, basically says that the 24th Amendment is legal, which it has to be because it's an amendment. Like you can't, an amendment to the Constitution can't be unconstitutional. You understand that concept, right? And other minority groups, you need to understand that we are approaching the point, and depending on what statistics you look at, basically anywhere from, I've seen as early as I believe 2035, 2050 is usually a more common guess or estimate as to when the United States will become a minority majority country, meaning whites no longer make up a majority of the United States. They will only make up a plurality, which means, because we claim to be a democracy a lot of the times, majority rules, all right? This just gives you a breakdown of like what states have the most diversity, right? And that's where I'm from, with 8%. Native Americans, this one's a little bit complex in large part because Native American, I mean, obviously Native Americans are here before, like they're native to America, right? They're here before white folks. Yet there's some really complex issues. You actually look at the Constitution. The Constitution mentions Native indigenous populations or Native peoples on a couple of different occasions and treats them differently. They're not deemed to be U.S. citizens. In many instances, their land is actually not deemed to be U.S. land. They maintain some autonomy. And so there's some discriminatory issues as a result of all of this because they don't get citizenship until 1924. And then we'll get to that concept as how citizenship plays into all of this as well. Hispanic Americans, this is our largest minority group. They make up a significant part of the population in a number of our states because these are 3 states that are no longer white majority states, right? These are minority majority states. Hispanics have been deemed to be a suspect class via the Constitution because there have been issues of discrimination against them. That being said, when you look at illegal immigration, and not to imply that all illegal immigrants are Hispanic, because they're certainly not, but it's obviously what we talk about most frequently. There are some questions with illegal immigration as to what sort of rights they have. So are those individuals who are not U.S. citizens, are they subject to the protections in the Constitution? And there's really no clear answer on this. It is a wildly complex issue. A lot of Americans can sort of agree that they're afforded freedom of speech or free exercise of their religion, but they're not necessarily in agreement on whether or not illegal immigrants can be subject to warrantless searches, right? or if they can have sort of certain, warrantless seizures or things like that. Asian Americans, this is a fast growing group in America. The biggest issue with discrimination for Asian Americans, historically you have Korematsu, which in turn a whole bunch of Japanese, right? So like there's the picture, kind of looks like a Nazi concentration camp, doesn't it? It's basically what it is, right? It's a concentration. I mean, there's no way around it. It's terrible blight on U.S. history, no worse than slavery, but it is what it is. Like we round up Japanese during World War II and threw them in big holding pens, and they got no habeas corpus and nothing else. I do want to call attention to also with Asian Americans, because you understand that as a part of discrimination comes sort of like bias and stereotypes and things like that, right? And so if we were to stereotype Asians, like what's the first thing that comes to your mind? They're smart, right? Oh, they're smart. They're hardworking, right? Like you need to understand that there's actually sort of toxic positivity as it pertains to Asian American immigrants, because a large number of them come over here and they don't have opportunities, right? They come over as sort of regular immigrants that are working multiple jobs and just trying to create a better life for themselves. But we have this sort of common belief that like, oh, all the Asians are smart and they go to college and they're studious and they're good, and that's a gross oversimplification. Okay? Muslim Americans or Arab Americans, obviously this is a small group in the United States in terms of our population, but it is a group that gets discriminated against, or that discrimination matters toward now because of 9/11. Obviously, you have a whole number of Americans that are sort of fearful of them. This concept down here with the illegal detentions, this is one of those things, just like I told you with Hispanics. If we pick up a Muslim in Syria or Yemen or wherever in the Middle East, and we detain them indefinitely in Guantanamo Bay, Cuba, are we in violation of their rights? Right? Do they have rights under the Constitution if they're not a U.S. citizen? Okay? In fact, from a military perspective, we put these people in Guantanamo Bay in Cuba. Okay? And the United States military does not refer to them as prisoners. They don't refer to them as prisoners of war. They refer to them specifically as detainees. Okay? Just so you understand the difference. Detainee basically means that you have been stopped and held by the government without having any charge brought against you. You have been charged with no crime. You have seen no judge. Understand the police are allowed to detain you. You can actually be detained by the police for no reason for up to 24 hours. Like literally no reason. A police officer can stop you on the street as you walk home and detain you. And I would actually advise you, if a cop ever stops you and and just ask them, am I being detained? If they say no, walk away. Okay? If they say yes, they are legally allowed to detain you. And then at that point, if you walk away, then you're going to get charged with resisting arrest, which is a little ridiculous because you're not under arrest. Women, obviously, women have been discriminated against as well. This is a bunch of the different things that we're going to talk about. They did get the right to vote. Obviously, it took until 1920. If you were in my dual U.S. history class, you would learn a lot more about like women's history and feminism. I'm not going to go through all of it now. Depending on like what scholar you look at, there's anywhere between 2 to 5 different waves of feminism in U.S. history. I don't really care about that. I do need you to understand that the right to vote was obviously the first thing that they were fighting for. Since that point in time, there has been less gains amongst women because there's less unity in sort of what they're fighting for. You do have second, to me, this is third wave. So to me, I would call this third wave feminism. Your textbook refers to it as second, which is why I left it in here, second wave feminism. But this is sort of piggybacking off the civil rights movement of the 1960s in order to try to get women more rights. They did create the ERA, although it did not get ratified. But ultimately, some of the things that they're looking for are things like wage equality. Now, this, again, like a lot of this stuff is actually relatively controversial because there's ways to explain away wage inequality, right? You take myself and my wife, for instance, right? We're both teachers. We have been teaching for the exact same amount of time. We both had the same starting salary at LCISD. Guess what? I make more money than she does because I coach, right? Because I'm willing to do additional things that women don't always do. And part of the reason, for, like in my family, part of the reason that my wife doesn't do that, the reason she doesn't coach is because we have small children, right? So she takes care of the kids when they're not in school, right? I didn't coach. So is that a wage gap issue, or is that simply the fact that I work more, therefore I get paid more? Depending upon how you look at some of those studies, that's what comes out. Additionally, when you look at sort of wage discrimination, if you were to take a libertarian stance, right, and we could really apply a libertarian stance to sort of discrimination as a whole, libertarians would argue that you don't put any constraints on the public sector and the marketplace at all. Because the reality is, that, let's just say for the sake of argument, that the wage gap is accurate, right? And that women only make 83 cents to what the men make. And with everything else being equal, if I had a business, guess what I'm going to go do? I'm going to hire nothing but women. And I'm going to pay them 90 cents to what I would pay a man. Because now if you're a woman, you're like, hey, that's like a 7 cent per dollar raise. Like I'm making more working for Baker's company than I would be for somebody else. And it's the same job, same work. Why wouldn't I go there? And I, as a business owner, by only hiring women and paying them slightly less, would be like, hey, I'm saving money on my labor costs. That benefits me as well. And libertarians would argue that ultimately, if you took out all protections, that the government would, or excuse me, that the marketplace would regulate itself. Okay. That being said, you do need to understand that when you look at sort of long-term historical discrimination, the marketplace can't really fix that on its own, right? So when you look at some of the Civil Rights Acts of the 1960s, that's probably necessary, especially at the time. Okay. As far as employment goes, you cannot discriminate based upon the gender now, right? So you can't not hire a woman solely because she's a woman. You can't not hire a woman because she's pregnant. Like there are teachers that get new jobs while pregnant, and schools know like you're going to miss a significant amount of time that year because they can't not hire you if you're qualified. Okay. As far as education goes, you do need to know Title IX. If you actually were to walk out of this room and look at some of the posters on the wall here, there's a Title IX poster so that you understand what your Title IX rights are. And we need to have the same sort of economic opportunities for women as we do for men. Okay, so public schools like Virginia Military Institute, which is actually funded by the state of Virginia, they cannot be a boys-only school, right? Because that's discriminatory. When you look at things like athletics, you have to have an equal number of boys sports as you do girls sports, right? Which is relatively easy to do because you have boys basketball and girls basketball, boys wrestling and girls wrestling, baseball, softball, football. We have volleyball, but most places offset football with cheerleading. What? My high school offset it with women's lacrosse, yes. But we did not have boys lacrosse. I mean, lacrosse is one of those sports that usually it's very easy because you have men's lacrosse and women's lacrosse. Although if you actually ever play lacrosse, they're not the same sport. They're not even remotely close to the same. And don't worry about it. Military service. Obviously, women are allowed into the military. Women make up service members in every branch of the military, although they're a relatively small aspect. The Obama administration in 2008, I don't know the exact year, but the Obama administration got rid of the stipulation that said women could not serve in combat roles, right? So when I was in the Marine Corps in 2001, if you were a woman, you could not be in the infantry, right? Which, believe it or not, it actually makes it harder for women in the military because the number of like medals and accommodations and things like that you get, the better you get promoted, right? So for men, like it was relatively easy to get things like a combat action ribbon, or not that you were like aiming to get a Purple Heart, but obviously you could get one. Whereas for women, the likelihood of that was significantly lower because they were not in combat positions.
We do need to understand, and again, this is sort of one of those discriminatory aspects that is generally deemed to be acceptable. Only you four guys in here, like you have to register for the selective service when you turn 18. The ladies in here, you do not have to register for the draft. Yeah. Now, I will say, now that you're eligible for combat positions, though, that could change. Okay. Sexual harassment is deemed to be a form of discrimination. Okay. The court has upheld that over the course of time. Just understand that that's a part of what we're talking about in terms of discrimination. We're not going to go into sexual harassment in great detail. But it is deemed to be discriminatory in its nature if you create a hostile work environment. Okay. And that pertains to race as well, right? So the courts have generally upheld that, like, if you work with somebody and you're black and they just keep telling like racist jokes or they use the N-word all the time, like that is a hostile work environment and that is discrimination. Okay, even if they don't necessarily have power over you. Last set of groups here: old people, people with disabilities, and LGBTQ. Okay, so we do have issues in terms of old people. We do have some age discrimination issues. Although we find now you cannot deny old people a job simply because they're old. Okay, you can find other ways around that, but yeah, can't deny them a job simply because they're old. People with disabilities. This one's probably a little bit more important than the age discrimination because sometimes you look at sort of direct discrimination or direct attempts at discriminating against people with disabilities, and sometimes there's sort of like unintentional discrimination, right? One of the things that we got to try to do to get rid of unintentional discrimination is the ADA, or the Americans with Disabilities Act of 1990, right? So if you're unaware, LCIC just finished building a new press box in the stadium, yes? That press box has an elevator now. It has to have an elevator because of the ADA so that a wheelchair-bound individual could get to the press box if need be. Prior to the building of the new press box, the school discriminated against, really. Like if you were in a wheelchair, you could not get to the old press box. Okay? Now, that was okay because that stadium is way older than 1990. And so therefore it was grandfathered in. Again, we use that term grandfather clause. They didn't have to have an elevator because it was built before 1990. But once you renovate, which is what they did, you have to be in compliance with the ADA. So they had to put an elevator in. And so that's sort of the concept of your accidental discrimination or your unintentional discrimination is things like access. Obviously, all public buildings now that are multiple stories have elevators, they have wheelchair ramps, they have things like that in order to try to create that opportunity. LGBTQ, they obviously fall into, well, they're not actually a strict scrutiny class or a suspect class yet. They have not always been held with strict scrutiny in the instance of discrimination, but obviously they have fought to end discrimination as well, whether that is sort of marriage equality, or the concept of equal protection under law, whether it's private behaviors, which both of these Supreme Court cases up here are basically about anti-sodomy laws and the sort of protections you have for the privacy of what you engage in your own home. Okay. Don't ask, don't tell was a small step in the right direction for gay service members. It was created in the 1990s under the Clinton administration. Prior to the Clinton administration, you could not be gay and serve in the military. By the 1990s, now you could be gay and serve in the military. You just couldn't tell nobody you were gay, but you had to stay in the closet. And your command, right, like your superiors, they weren't allowed to ask if you were gay. That went away with the Obama administration. So in addition to opening up combat roles for women, they also got rid of don't ask, don't tell, and homosexuals can now openly serve in the military. Okay? And then obviously same-sex marriage, right? Again, in the 90s, under the Clinton administration, we had DOMA, which is the Defense of Marriage Act, that prevented or limited the equal protection under the law, which is what anti-discrimination lawsuits are about. they did not have the same protections. So if you were in a same-sex marriage or same-sex coupling, your spouse would not have survivorship benefits if you died, right? So like if you had a pension or you were getting Social Security and then you died and you were in a same-sex relationship, your spouse would not get survivorship. Your spouse would not be entitled to your possessions or things like that. Okay. It does bring us to affirmative action. Last thing I want to cover. This is an attempt to try to overcompensate for past discrimination. And when you look at sort of affirmative action as it pertains to universities, because that is important. Universities are allowed to take race into account in their admissions, so long as it's not the only thing that they take into account. And that is a beneficial thing because you want diversity in education, because you want diversity in thought, right? Schools are supposed to be a marketplace of ideas where we challenge each other's beliefs and we open ourselves up to new ways of thinking. Racial diversity helps achieve that. Okay, so that's it. We're done. You've got your quiz today. I'm sorry I took all the second period for that since it didn't record last night, but there you go. All right, so have a good day. You can leave as soon as the bell rings again. Guys that are here via Zoom, we're done. Thank you very much. Y'all can go. Put your name in the chat before, whatever. You already know.